Hello students and welcome to the lecture. So students, basically in this lecture, we are going to start the new topic which is the Attorney General of India. Alright, so we are going to see about several things which we have scheduled for the discussion under this particular series of the Attorney General of India. Like you could see that we have the introduction about the Attorney General of India. Thereafter, we have the appointment and terms regarding the Attorney General of India. Thereafter, we have the duties and functions which are performed by the Attorney General of India. Then, what are the rights and the limitations provided to the Attorney General of India? Then, what do you mean by the Solicitor General of India? And which are the articles which related with the Attorney General of India at a glance? Okay, so you could say that these are the topics we have scheduled for the discussion under this particular series of Attorney General of India. All right, so let's begin with the introduction part. So basically, the Attorney General of India is a constitutional body. All right, is a constitutional body. And why we could say that? Because if you look at here, so there is an Article 76 which is provided in the Indian Constitution, and that has provided for the office of the Attorney General for India. Okay, so remember, the Attorney General of India is an constitutional body as per the Article 76 of the Indian Constitution. And basically, who is the Attorney General of India? He is the highest law officer in the country. Okay, like there is a creation of law officers in the country, which are the members of the law councils, and these are the persons who basically advocated for their clients in the courts. So basically, the highest law officer in India is the post and the designation which is known as the Attorney General of India, powered by Article 76 of the Constitution. So remember this thing. All right. So basically, now after finishing the, you could say the introduction. Introduction is just a simple thing because we have to just see that what is Attorney General of India, why we are talking about it. So what we have seen that it is the highest law officer, constitutional body provided by the Article 76 of the Indian Constitution. Now, what is the appointment and what are the terms of the Attorney General of India? So basically, the Attorney General is appointed by the President of India. Now, it is a very, very important thing. Like in the question, or you could see in the examination, the question may be like this: who is appointed the Attorney General of India? Who is appointed the Attorney General of India? And if your options are like this: Prime Minister, okay, Parliament, Supreme Court, President. All right. So mostly time when this type of questions comes, and if the options are like this, so there are high chances that many of you will mark the Parliament. Why? What is the reason? Because the maximum powers of the Constitution has been restored to the Parliament. All right. That's why whenever there is any kind of post which is for the Indian purpose, or you can say the national purpose, so generally we mark the Parliament as an answer, which is oftenly right answer, but not in all cases or not in such cases. The Parliament has nothing to do with the appointment of the Attorney General. However, he is the highest law officer, but even the Supreme Court is not involved in the appointment, nor the Prime Minister. The correct answer is the President. The President is the person or in the authority who could appoint the Attorney General of India. All right. So always keep this thing in mind that basically the President of India is empowered by the Constitution to appoint the Attorney General. He must be a person who is qualified to be the appointment of a judge of the Supreme Court. Okay. So basically, the person who is going to be appointed as an Attorney General, he first meet the qualification to get appointed as a judge of Supreme Court. So basically, if we talk about the Supreme Court judge, then you could say the qualification of Supreme Court judge is like this. He must be a citizen of India, okay, and he must have been judge of some high court for 5 years or advocate of some high court for 10 years or an eminent jurist in the opinion of the president. So basically if we write down them in the simpler form, like the qualifications of attorney general. So what are the qualifications? There are 4 qualifications. Okay, first, must be an Indian citizen. Second, must be a judge of high court. Let me write down again. Must be a judge of high court for 5 years. Thereafter, must be an advocate in high court for 10 years. And third, must be an eminent jurist in opinion of the president. Okay, so these are the 4 qualifications. First, as we had seen, that he must be Indian citizen. Second, that he must be a judge of high court for 5 years. Third, he must be an advocate in high court for 10 years. And apart from all this, it must be an eminent jurist in the in the opinion of the President of India. If the person qualifies all these conditions, then he could be appointed at the post of Attorney General of India. Okay, so just remember these qualifications. The term of AG or the Attorney General is not fixed by the Constitution. It means that whether he will be for 5 years, 6 years, or any other fixed duration, that is not decided by the Constitution. Further, the Constitution does not contain the procedure and grounds for a removal. Okay, like whether he will be removed by the impeachment and all, this is not mentioned in the Constitution. So basically, he entirely holds the office during the pleasure of the president. Okay, so as long as the president wants him to be remain as a attorney general, he could hold the post. That means that he may be removed by the president at any time. So whenever the president wants that the person who had been appointed as an attorney general should resign from the post, then he has to resign. Okay, thereafter he may also quit his office by submitting his resignation to the president. Conventionally, he resigns when the government council of minister resigns or replaced as he appointed on its advice. So basically what happened, like if we talk about his removal, and you could say about his quitting the job, so basically there is no standard procedure, there is no set of guidelines, there is nothing in the constitution for his removal. Okay, and basically it's totally depend upon the president that he could be in the office or be out of the office. But there is another thing, like there are 3 ways for his removal. Okay, first way, when president removes him, it is the first way. Second, when he resigns from the post. Okay. Third is when the Council of Ministers change or resign. So these are the three conditions on which basically he removes. First, as we had discussed, when the president removes him. Third, second, when he resigns from the post by submitting his resignation to the president of India. Third condition is then when the Council of Ministers change or resign. Why? Because they recommended the president to appoint that person on the post of Attorney General. Okay, they recommended the president to appoint that person on the post of Attorney General. All right. So when they basically removes or they resigns, then automatically the Attorney General has to resign. Thereafter, the remuneration of the AG or the Attorney General is not fixed by the Constitution. He receives such remuneration as the President may determine. It means that the salary and allowances of the Attorney General is not mentioned or fixed by the Constitution. Basically, it is entirely depend upon the President who may determine that what price and what salary and allowances should be given to the person who has been appointed as an Attorney General of India. Okay, so here we have finished this. Now, what are the duties and the functions of the Attorney General? As the Chief Law Officer of the Government of India, the duties of AG including the following. Remember that he is the highest and the Chief Law Officer, but he is responsible to the Government of India. And here, when we talk about the Government of India, then which government we are, you can say, denoting? Basically, we are denoting the Central Government of India. Okay. So the first thing which we could see here, to give advice to the Government of India on such legal matters which are referred to him by the President. Like suppose there is something like government is thinking about some legislature or bill to present in the parliament. Okay, the government is thinking over it, but what happened? Then the government is required the legal advice. Like government is looking for the complete implementation of the legislature or bill, so that's why they wants to fill the legal intervention gaps. All right. So in such a thing, basically, the President of India refers the matter to the Attorney General. Okay. Then the Attorney General is required to look on the matter and go through all the details, then provides a legal matters advice to the government on the particular legislature or the bill. It is his first duty. Second is to perform such other duties of legal character that are assigned to him by the president. Okay, so basically, the president is the one who had appointed him at the post. So basically, the president could give in him the legal characters and he is required to perform such duties. He could not deny. Okay. Third is to discharge the functions conferred on him by the constitution or any other law. All right. So if the constitution or any other law prescribes some functions on him, then he is required to discharge it. So basically there are three parties, or there are three things which could gives the work or the duties to the Attorney General and which is required to perform. First is the central government can seek the legal advice. All right. Thereafter, President could give him the legal matters and he is required to perform of the duties. Third is that if constitutional or any other law confirmed any type of duty on him, then he is required to perform the task. Okay. So that is the duties and functions. All right. And this is the responsibility of Attorney General of India. All right. The president has assigned the following duties to the AG. Okay. Like president who has assigned the following duties to the AG. The first is to appear on behalf of the government of India. Remember, here we are talking about the central government in all cases in the Supreme Court in which the government of India is concerned. Okay. So remember, whenever someone will file the PIL, okay, PIL stands for public interest litigation. That is, we will cover in the upcoming lectures. So suppose if there is a person who has filed a PIL in the Supreme Court against the central government, okay, then what will happen? That the central government and the central government's executive, it means the prime ministers, the ministers, and all, they will not directly go to the court, okay, because they have other duties to perform. So they could not directly go to the court and start hearing the case, participating in the case, and so on. So basically, on behalf of the government, the one who is going to the court to present the government stance is the Attorney General. All right. So Attorney General is the person who is going to the court and present the government stance. Okay. And basically, another thing is to represent the government of India in any reference made by the president to the Supreme Court under Article 143 of the Constitution. Okay. So basically, what happened? That Article 143 empowers the Supreme Court to give some legal advice on to the President of India on matters like foreign relations, territory extent, and all. Okay, we will see in the lecture of Supreme Court that what does it mean. But remember that by the Article 143, the Supreme Court could give the advices to the President if the President requires. So suppose the President of India requires the advice of Supreme Court, the Supreme Court provides it, and now the President of India seeks the government of India to take the action on it. So what is the stance of the government of India? That will be projected before the Supreme Court by the Attorney General of India. Like suppose the Supreme Court of India wants the Attorney General of India, wants the government to take some action on the foreign affairs. And the president take the advice of Supreme Court on this. And then the president made the reference to the central government. So what the central government is thinking on the proposal is to be presented before the Supreme Court by the Attorney General of India. Like what is the stance of the government on the legally terms, then that will be advocated by the Attorney General. Third, to appear when required by the government of India in any high court in any case in which the government of India is concerned. Okay. So remember, as we had discussed, that he is going to represent the government of India whenever the matter bring to the Supreme Court. The similar thing is applicable if any, you can say, application files in the High Court regarding the central government. And if the central government is concerned in that case, so what will happen? That the Attorney General of India will represent the central government in that particular court. All right. So these are the three duties which have been assigned by the President of India to the Attorney General of India. Okay. Thereafter, now let's talk about what are the rights and the limitations of the Attorney General. In the performance of his official duties, the Attorney General has the right of audience in all courts. Okay, the Attorney General could go to the all courts and could be in the audience. All right, within the territory of India. Further, he has the right to speak and take part in the proceedings of both houses of parliament or their joint sitting and any committee of the parliament of which he may be named a member, but without a right of vote. So he could not only be the audience in all courts when the central government is concerned, okay, within the territory of India, but he also able to speak and take part in the proceedings of both houses of the parliament, even in the joint sitting and any committee of the parliament of which he may be named a member, but he has no right to vote because he is not a member of parliament. He is just a guest of parliament. Okay, he enjoys all the privileges and immunities that are available to the MP, but he is not an MP. Remember this thing, or the member of parliament. Following limitations are placed on Attorney General in order to avoid any complication and conflict of duty. First, he should not advise or hold a brief against the government of India. He should not advise or hold a brief in cases in which he is called upon to advise or appear for the government of India. Okay, so these are the other two limitations forced on the Attorney General. Thereafter, he should not defend accused persons in the criminal prosecutions without the permission of government of India. So basically, however, the Attorney General has been appointed as an highest law officer for the government of India. But apart from this, he is also allowed to perform the personal practice. So he could take any case in the civil matters. But when it is a criminal prosecutions and he is to defend someone or the accused, then he could not take the case without the prior permission of the government of India. Until or unless the government permitted him to do so, he could not attend the case. He should not accept appointment as a director in any company or corporation without the permission of government of India. Should not advise any ministry or department of government of India or any statutory organization or any public sector undertaking unless the proposal or a reference in this regard is received through the Ministry of Law and Justice and Department of Legal Affairs. All right. However, the Attorney General is not a full-time counselor for the government. He does not fall in the category of government servant and he is not debarred from the private legal practices, as I have told you, but only in the civil cases. All right. If he is required to defend anyone in the criminal cases, then as I have told you, that he must obtain a permission from the central government. Without obtaining the permission, he could not participate into the things. Thereafter, who are the Solicitor General of India? So, in addition to the AG, there are other law officers of the government of India that are the Solicitor General of India. And Solicitor General of India are the they are the Solicitor General of India and Additional Solicitor General of India. They assist the Attorney General in the fulfillment of his official responsibilities. Should be noted here that only the office of AG is created by the Constitution. In other words, Article 76 does not mention about the Solicitor General and the Additional Solicitor General. So remember, when we talk about the Attorney General, then it is the constitutional body. All right. And the Solicitor General is the extra constitutional body, because the Constitution does not carry any provision regarding this. The AG is not a member of Central Cabinet. There is a separate law minister in the Central Cabinet to look after the legal matters at the government level. He is only required to perform his duties when the matter refers to him. So these are the articles related with the Attorney General of India at a glance. Article 76 stands for the Attorney General of India. 88, Rights of Attorney General as respect the House of Parliament and its committee. And third, Article 105, Privileges, Powers and Immunities of the Attorney General. All we have discussed. So students, basically in this lecture, we have finished this lecture. So we have finished the Attorney General of India. In the next lecture, we will start with another important thing. Till then, just revise all the facts and figures we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture and thank you.